In this video, we are going to go over how to set up a listing in Brokermint. There are two ways to do this. If you're going to be working with your transaction coordinator, then you fill out the TC seller. You can do the EBBA or ERS only brain dump. And that way they then have all the information for creating your ERS. But again, more of the focus of this video is going to be you need to know how to set this up in Brokermint. Your transaction coordinator may not always be available, particularly weekends and after hours. And it's also important to know the steps. So when you log into Brokermint from your dashboard, you want to switch to transactions. On the transaction, we're going to go create new, select type. This is the type of sale that you're going to be listing. We're going to start with traditional sale because that's most of what you're going to do. If, in fact, you're in a short sale situation, then you want to talk with the broker. Marty's got the most experience with short sales because there is additional paperwork that is required as part of a short sale. But most of what you're going to be doing is traditional sale. Status, we always start as an opportunity. This means we're still in the process of getting it prepared. And obviously, if this is a listing, we represent seller. Any field in pink in Brokermint has to be filled out before we can move on. If you don't know what the price is that the buyer is going to list, seller is going to list it at yet, then put a 0 in there. There does have to be something in there. Okay, mandatory field. This does require that you put your source of where you met. I'm going to put a past client. Now, commission amounts. This becomes important because the commission amount that is in here is the total amount you can receive as an agent. If your seller has agreed to do a 6% and split it 3 to you as seller and a potential 3 to buyer, however that's been negotiated or prepared. If this hasn't been negotiated yet and you're still going to be meeting with them, with a seller, at least have something in there. If we need to correct it, then we can correct it. Seller names. We're going to go with our famous McTrain face here as seller number 1. When you prepare this, you need to make sure that all seller names that are on title have to appear. If there's more than one seller, if there's more than one name on title. If the title is under a trust, if title is under an LLC, whatever title has to be listed as the seller. If it's a trust or a title, trust or any type of other type of title, such as an LLC, then we have to have the documents for those. The seller has to confirm that they have legal power to sign as seller. In this case, we're going to add another contract as a seller. We're going to go with Stoppy McStop or Stoppy Caboose again. And obviously, we need to put you as the listing agent. As soon as you start typing your name, it's going to attempt to fill in who you are, assuming, of course, you spell your name correctly. Now, checklists. We're going to go down here to PREX listing prep. Click on that. Transaction coordinator. Mark Beckstrand and create. Now, when it brings you to this screen, you're now going to come over here to documents. We're going to treat this in a unique way. We're going to go to the required document list here, and you're going to notice it brings up the affiliated business agreement. We still have to do that because of, even though they're selling, we have to do that because of our real advantage title relationship. Exclusive right to sell. You don't have this, you can't sell the property. if you want to include any addenda to the exclusive right to sell. Again, we have some agents who will add an addendum that if the seller at any time decides to cancel, the seller will pay a preset amount to the brokerage to cover the brokerage costs and your costs that have been incurred through the course of the listing process. In this case, we're not going to do that. We're going to get rid of it. Wire fraud alert disclosure that is required by the state of Utah. MLS exclusion form. This form is required by the MLS. If the listing is not going to be going live within 24 hours, this has to be filed with the MLS. However, when you submit the form on the MLS, it's a fillable form on the MLS that as soon as you click submit, it goes away. We've brought it into this setting so that you can have a signed copy so that your sellers understand what they're committing to on that form. We're going to treat this as if the property is in a homeowners association, and we're going to go ahead and complete the request to Homeowner Community Association for documentation. Now, we're also going to treat this as if the property were built before 1978. I'm going to show you where the lead-based paint disclosure is already built into this on its own screen. So once we get all of this in here, we're going to hit next. Want to make sure that we have the listing agent correct, seller one, seller two. If there are any other seller names, if there aren't, remove those. Yes, I want to delete them. Otherwise, it's going to try to attempt to put in signature fields for them. Now, all of the documents are prepared for initials and signatures. We're going to go through the documents in terms of what they are on a different video, but you want to make sure signatures, again, date, the signatures are built into the date and timestamp, same with initials. So some agents choose to just work with just that date and timestamp. You can go ahead and use date and time and add a block if you want. Exclusive right to sell. This is now where you make sure everything's spelled out properly. Your name as the authorized agent. Now, Prime Real Estate Experts LLC as the brokerage. Training McTrain Face and Stoppy Caboose as the sellers. Now, you have to have the complete address here. And this again becomes, this date is the expiration date, how long this will be active. If you put today's date, it's only active for today. So we're going to put a date, end of August, whatever you choose. If it's blue, you need to make sure you fill it out. Brokerage fee. Now, this we need to make sure it gets filled out properly. On the seller's brokerage fee, this is the amount that the seller's brokerage is going to be receiving. So if you've negotiated the 3%, and if you're paying a transaction coordination fee, if it's not, depending where you're at on which compensation plan you're on, if you are paying that out separately, or it's going to be coming out of your commission amount and you want your seller to pay that, you can include that here. If it's not here, we're going to assume that you're paying it out of your split. Seller's brokerage fee with an unrepresented buyer. As we go through the paperwork, we explain to the seller at this point that there is the potential for a buyer to come in who's choosing to act as an unrepresented buyer. That puts an additional burden on you as the agent to make sure that everything is going properly. We cannot represent that buyer. We cannot really answer a lot of questions for that buyer. There's strict rules that we have. We can provide blank forms to them, and we can help in that aspect, but it oftentimes puts an additional burden on you as the agent. Plus, that person is probably not going to cannot receive a buyer agent commission. They're not a registered agent. So you can negotiate with your seller in that situation. If you say, look, because of this additional risk and liability I'm taking on, I'm going to say, we'll take whatever amount we're going to say. I'm going to say 1% on this more. But that means they're paying 4% instead of 3%, but they're not paying whatever amount in 2.3 that they agreed to pay for buyer agent commission. Now, if they are offering a buyer agent commission, that amount goes here. Again, percentage or dollar amount. If they are offering a percentage, put the percentage in there. If they're if they're offering a strict dollar amount, put the strict dollar amount in. This is the one time when I'm going to say leave a spot blank. And that has only come about because of recent litigation regarding this form where a seller's agent had put 3% or zero in there, and their client's attorney said, hey, that's a zero. In fact, there's a zero on that, so you don't have to pay it after all. It also came about on a buyer side. So if it's a strict dollar amount, put it there and leave the percentage blank. If it's a percentage, put that there. Remember, this is the total amount they're obligated to. The buyer agent could be receiving less than that if that's what they agreed to. Seller does not authorize the company into a written compensation agreement with the buyer's brokerage. When you go watch the video about the various compensation arrangements that are available, one of those is through the compensation agreement between brokerages. That is a separate form that indicates that the seller has already agreed to pay this amount of a compensation amount, and that relationship now exists between brokerages. If you click this, it says don't use that form at all. Honestly, it's going to be a personal choice between you and your seller. I leave that blank. I have yet to actually use that form because my preference and what we're seeing most buyer agents' preference is to use the REPC as the negotiating tool. Okay, protection period, always fill in however many months you want protection after this concludes, that if they go ahead and sell to someone that was part of, you'd introduce them to the process. Now it just becomes a matter of, as always, making sure everything's filled out. They need to understand that we are going to disclose where we got the square footage amounts. If you're using the prior MLS, then you need to click other and put prior MLS listing. That's a very common way of a resale. Very infrequently, you'll have building plans. Occasionally, you may have a prior appraisal or county records. County records can be a little more difficult in working with if you're looking at a multi-level home, townhomes especially, where it will list the above grade square footage as one number, even though it could be multiple levels, and trying to parse those out as to which level is which can be difficult. You need to mark whether or not there are attachments and whether or not the seller is a foreign investor or foreign person. 99 times out of 100, you're going to be marking is not. Okay. Now, as we go through this, wire fraud alert disclosure, this is the exact same form as on the buyer side. You simply need to make sure company name, sellers, or your name is in there and sellers' names are in there. Pre-built, 4 signatures. MLS exclusion form. Again, this form has to be completed on the MLS. However, it is completed through the forms, MLS forms, while you're preparing before you prepare the listing. There are 3 options on this. For the time being, there's a potential for a 4th coming in the future. When that happens, we'll do an update on just this form. Do not submit the property to the MLS until a specified date. If they already have things on rolling and they're looking at a specific date that they want to go live, choose that, select that one. You have to enter the date. Do not submit the MLS to property until a listing is publicly marketed. This is the most common choice because we're still trying to get pictures ready and signpost up and key box on and all those steps that go toward preparing it. But you're going to have a listing agreement signed to be legally representing them to do those things. But this leaves it open-ended. Once everything is in place and then they say yes, then this can be clicked. Do not submit the property to the MLS while listing agreement for the property is in effect. Rarely we have used this. This has most frequently been used on properties that are rehab properties. They're not going to be sold on the open MLS because most of the buyers that are going to be interested in it, you've got if you have a group of investors that you know are going to be interested in buying this home as a fix and flip, and the seller doesn't want to go through the hassle of having an open house or multiple showings of the home and all of that. You can mark, we're not going to put it on the MLS. We're going to direct market it to this specific group of people. We're going to say, look, from this time to this time on a specified date, you can come in and see it. And then we're going to take offers, however you want to market it. But it cannot be publicly marketed. It can't be, it won't be on the MLS. There won't be a sign out front. There's not going to be any references to it on social media, anything public. Make sure that that's signed. Okay, request to the Homeowners Association for documentation. This goes to the HOA as a reminder that they are legally obligated under Utah law to provide the HOA documents. So all the covenant codes and restrictions. This is where we're going to get HOA minutes, get HOA budgets, all of those. The CC&Rs are public record, and title can pull those when they do a title search. What they can't oftentimes get their hands on are all those other things that are important to a buyer, particularly HOA meeting minutes. Is there some kind of major event coming up that the potential buyer needs to know about? Budget, if the buyer needs to look at it, and the lender needs to see that there's an adequate emergency budget, all those documentation. So we have to fill in the HOA association name, your name as the seller, the address, the seller phone number, and email contact. Those have to be put in there because the HOA is going to may reach out to the seller to verify it, but that's also probably who they know. And then what are we looking for? We want a copy of any restrictive covenants, and we're going to want a copy of the most recent minutes. And then there's a reminder from the association to the association how those can be provided to you, and a reminder of the penalties that the HOA could potentially be facing. Most HOAs, as you're taking a listing, you'll see that they're under, many of them are now under HOA management companies, and this would go to the HOA management company. They've got a procedure, and they know that they don't want to be paying a $25 a day penalty for not getting this sent out in the time within 6 days, which is considered a timely manner. Now, they can charge you for 10 cents a page, but that's only if they're sending paper. Most of them are just going to send it. I have yet to have that happen. And the most realistic way is it's going to be in a PDF format, which then makes it possible to upload it as a document when you get your listing prepared so that it's also there available for potential buyers to see. All right, I'm going to save and close this one yet for now. And we're going to treat this as if it were a home built before 1978. You'll notice that the lead-based paint pamphlet is right here, and the lead-based paint disclosure and pamphlets. Lead-based paint pamphlet. There are many brokerages and some agents within our brokerage, when they upload this, to verify that the sellers are aware of it, will actually have them initial the page, the last page to say, yes, I saw this, and I know I have to provide it. This then goes with the listing with the lead-based paint disclosure. So we're going to pull this one up. Agent and buyer. We represent the seller, so we're not going to put buyer information in there. But we do need to add a signer to this, and that is you as the agent. Listing agent has to sign this form. So as you go through, concerning the property address, the seller then has to indicate which of these in section 1 they're going to mark. If they do actually have some kind of lead-based paint report or knowledge of presence of lead-based paint on the property, you mark letter I. I've had that happen once where a seller, when they bought the home, had a lead-based paint test done. Home was built in the 60s in Kearns, big surprise. The windowsill had lead-based paint. Most sellers honestly don't know, especially if they were born after 1978. Lead-based paint just isn't a part of their world. So most of the time, they're going to be marking the seller has no knowledge. Now, in order to make this work, we're going to come down here and click on the Fill Now and fill it in. Now, records. Again, if the seller has had any kind of test done, then they're going to mark what kind of tests they had, and how they documented it. And there are tests available. You can even go to Home Depot or Lowe's and get tests. It is a destructive test in the meaning that you have to take chips of paint from the property to have them tested. So again, most of the time, seller is not going to be aware or have any records, and they're going to mark that. Now, seller has to sign here and here. You as the agent have to sign as well. So if your signature doesn't show up, then we're simply going to go add a signature. I'm going to go ahead and put the box in there and click on it to reassign it to you as the agent. Add the date and time. We're going to put the date on there. You notice it's the same color as you. You have to sign this, that you have acknowledged that you are aware of what this form says. We're not going to fill out the buyer's side. That is incumbent, of course, on the buyer's agent. And save and close. Now, obviously, you want to send these for signatures. So when you're ready to send them for signatures, edit e-sign. Again, you make sure everything is filled out properly. And then you can send for e-signature, make sure the emails are correct, and you can put your own personalized message in here. This bar, again, is the message bar. Please sign documents requested by Darren Webster. It's a bit vague, so I tend to put in there what kind of document it is and personalize this. And then you'll send it off. Required listing documents, click on it again, edit and e-sign, you can send it for signatures, and you're ready to go. Now, once we receive CC&Rs and any of this information, we're going to put that in there. One thing to pay attention to on the CC&Rs is whether or not there is an HOA reinvestment fee or any kind of transfer fee. That has to be disclosed in the listing. And that's typically stated, that amount is stated in the CC&Rs, or by you taking a couple of minutes, contacting the HOA management company by phone and email and verifying what that amount is. You can also look at prior listings for units in that same complex. However, those fees or amounts may change over time. So be very aware of what that is and verify. Okay, that's how you get your listing ready to go.